Welcome to HIPAA 2013 Omnibus Final Rule. My name is Ann Bachman. I'll be your presenter for this session. As you can see from the first slide, I'm a partner with Doctors Management and also director of the OSHA CLIA HIPAA department. I've been with Doctors Management 18 years now. Doctors Management is a practice management firm that has assisted doctors all over the United States for more than 50 years. We cover a lot more issues than just regulatory. The purpose of this session is to assist privacy and security officers in updating their policies and procedures to be compliant with the 2013 Final Omnibus Rule. Please honor the resources that have gone into developing this presentation, recognizing that it's the property of Doctors Management and may not be recorded, copied, duplicated, or distributed in any format. The DVD that you are listening to came with a hard copy of the slides you are watching. We recommend that you use the information here to update your policies and procedures, in particular your Notice of Privacy Practices, your Business Associate List, and your Business Associate Agreement. Staff training is required initially and periodically. Although this presentation is not specifically designed for that purpose, the Privacy Security Officer may determine that it would be appropriate for training individuals. Health Insurance Portability and Accountability Act of 1996, that's the full name of HIPAA, started a long time ago with Title I, Healthcare Access, Portability, and Renewability. The purpose of this is to protect health insurance coverage for workers and families when they change jobs or lose their jobs. And the main emphasis was to restrict the limitation or limit the restrictions that health plans can put on coverage based on pre-existing conditions. This Title I is enforced by the Centers for Medicare and Medicaid Services. Title II is Preventing Healthcare Fraud and Abuse, Administrative Simplification, Medical Liability Reform. This includes transactions and code sets. We now have the transaction formats 5010, which were designed to correct some of the problems found in 4010, but also to accommodate the upcoming ICD 910. The code sets would be CPT and ICD 9. We look forward to ICD 10 in 2014. We have the national identifiers, the ones for the providers and employers have been in use quite successfully for some time. We anticipate the national insurance plan or health plan identifiers in 2014. Unfortunately, the national individual identifiers have been put on indefinite hold due to a lot of pushback from the general community fearing loss of privacy and security. Privacy Rule of 2003, the Security Rule of 2005, both of those are enforced by the Office for Civil Rights. Let's look at the history of Title II. Administrative simplification, which is the transactions and code sets, the national identifiers, as already discussed. The Privacy Rule of 2003, the Security Rule of 2005, as mentioned earlier. And then the Enforcement Rule, which came about, or the Final Enforcement Rule came about in 2009. It was actually a part of the HITECH Rule. HITECH Act was the Health Information Technology for Economic and Clinical Health. It also introduced the breach notification, which kind of took a life of its own. We've heard a lot about that. And this all comes together with some modifications and some other bits and pieces to become the HIPAA Omnibus Rule 2013. For those of you who have been using Doctors Management HIPAA compliance services, you will be happy to know that our 2005 implementation notebook was actually updated numerous times until the 2010 manual that was totally revised for easier use and for the high-tech requirements. We also revised again in 2013 to accommodate the omnibus rules. Let's look at omnibus. What does this really mean? If you look at the definition of omnibus, it means a compilation of previously published or released works by one author or on one theme. It includes, as mentioned, transactions and code sets, privacy and security, enforcement, breach notification, and GINA. We'll have more about that later. A lot of what you've been hearing about the Omnibus Rule really relates back to the changes found in the HITECH Act. And then, of course, we've brought in GINA and some modifications. The Omnibus Rule was published on January 25, 2013, with a compliance deadline of September the 23rd, 2013. It brings forward a lot of components, but not all of the components, from the HITECH Act, and has some significant changes for all of us, but especially anyone who did not revise HIPAA policies and procedures to accommodate the HITECH changes. So we have a broadened business associate definition. We have some changes, some things that we've had to add to the business associate agreement. Because of some of the changes in patient rights for access to their protected health information and restrictions, we have to change our notice of privacy practices. And there's advanced enforcement, which is huge. The HITECH Act, which is Title D of the American Recovery and Reinvestment Act, which we also called ARRA, or the Stimulus Package of 2009. What was included in the HITECH Act would be the breach notification, the application of HIPAA regulations directly to business associates rather than just through the business associate agreement, restrictions on the sale and certain disclosures of protected health information, changes in how we have to provide an accounting of disclosures to our patients upon their request, and also some, once again, improved enforcement procedures. There were some things that were in HITECH that did not come forward into Omnibus. One was a requirement for clinical laboratories to release results directly to the patients after confirming the requester's identification without going through the provider. This came into conflict with many state regulations which require clinical laboratories to release results only to authorized individuals, primarily providers. So that is still pending. It may happen later. There was also a requirement for covered entities and business associates to provide to patients upon request a list of names of individuals who accessed their protected health information, and also to include in that accounting of disclosures uses and disclosures for treatment, payment, and health operations, which would have been very cumbersome. The Omnibus Rule applies to covered entities, we abbreviate that CE, which includes health plans, healthcare clearinghouses, healthcare providers who transmit information in electronic format in connection with the transaction that is covered by the rules, either directly or through a business associate. We have a broadened definition of business associates, and it's changed. The business associates are individuals or entities who create, receive, maintain, or transmit protected health information on the behalf of a covered entity. Are you a covered entity or a business associate? How do you know? Maybe you're both. Covered entities provide healthcare services or healthcare insurance. Business associates basically provide support services for covered entities. One covered entity may actually be the business associate of another covered entity, depending on what type of services they actually provide. One business associate may actually be the business associate of another business associate. We prefer to call these subcontractors. Examples of business associates and what they may do: claims processing or administration, data analysis processing or administration, utilization review, quality assurance, patient safety activities, billing, repricing, benefit management, practice management, legal, actuarial, accounting, consulting, data aggregation, and so forth, involving protected health information. Business associates may be health information organizations, e-prescribing gateway, document destruction companies if the protected health information is actually removed from the premises for destruction, personal health records if they are offered on the behalf of a covered entity, information technology support in many, many ways, practice management systems and electronic medical records or electronic health record vendors, and patient safety organizations. These have kind of been added to our original list of business associates. For a long time, we have considered this list of business associates as such. Accrediting agencies, maybe someone who is not CLIA but comes in and inspects the laboratories, document storage facilities, storage vendors, because in some situations they do actually have access to that information. Consultants, if they access protected health information, pharmaceutical reps who use protected health information to assist patients with getting discounted pricing or some sort of financial assistance, durable medical equipment sales reps who might measure the patients or otherwise have to access protected health information to provide the correct piece of equipment, cloud-based storage providers, and then subcontractors who create, maintain, or transmit protected health information on the behalf of a business associate. A lot of individuals and entities may be thought to be business associates, and perhaps they really are not. A covered entity that operates only as a routine healthcare provider, a health plan, or sponsor, or healthcare clearinghouse, not a business associate as such. They become a business associate if they provide other types of services. Housekeepers. Very often we tend to think because they might see something, pick up a piece of paper, overhear something, that they might be a business associate, but they don't create, receive, maintain, or transmit that information. The same with a security guard and most sales representatives. Waste haulers. Certainly anything that goes into your waste to be just picked up and taken away should be destroyed before it is removed. Conduits who simply transfer, deliver sealed envelopes. Telecommunication relay system. These are the folks that provide assistance for hearing impaired, and they're not considered to be business associates. Workforce members of the covered entity are not considered business associates. There are hybrid entities which have been addressed in the omnibus rules. They perform some functions of covered entity, but some functions that are not covered by the HIPAA regulations. We could have a university that is primarily a teaching institute, but also has a student clinic. In this case, the clinic would be a covered entity, but the remainder of the university might not. The university would then declare itself to be a hybrid entity, designating the clinic as the healthcare component, and then only the clinic would be under HIPAA. Another example of a hybrid entity would be a research institute, because part of the functions might might relate to protected health information, but there might be other departments, maybe those that just write grants or do support, might not have any way, shape, or form that they would touch, much less create, maintain, or transmit protected health information. So they would not be covered entities. We have a revised definition of workforce. Now, we have long understood that the workforce included anyone who does work that impacts or touches protected health information as part of the covered entity. But it now includes employees, management, volunteers, training, students, and anyone else who might handle, see, access protected health information for a business associate as well as for the covered entities. Enforcement. Oh my goodness, this has changed tremendously. The Office for Civil Rights is now responsible for enforcements. We now have inspections or audits, in addition to those triggered by a complaint, something that are called routine. The Office for Inspector General has mandated that the Office for Civil Rights conduct inspections that were not triggered by a complaint. These generally occur as follows. The practice will usually receive a letter requiring submission of a huge stack of documentation within 10 days. The auditor then has up to 90 days to review that documentation and schedule an audit. The on-site audit, you'll have sufficient notice for that. It could be anywhere from 3 to 10 business days, although not always. The auditing company, usually an accounting firm, will then draft a report to the covered entity and then give the covered entity 10 days to respond to that. The final audit report goes to the Office for Civil Rights within 30 days of receipt of the covered entity's response, but there is no requirement for the Office for Civil Rights at this point in time to respond back to the covered entity unless they have huge fines that they want to impose. In 2012, the Office for Civil Rights contracted with an accounting firm to conduct what was supposed to be originally 150 and it ended up being 115 random audits of covered entities across the United States. 115 covered entities across the whole United States is not significantly or not statistically significant. Business associates were not included in this pilot study. The findings are still being evaluated, and in fact at this time the Office for Civil Rights is asking for feedback, evaluations, whatever, from the general public, from covered entities, and all this will be used to improve the auditing process. And I can go ahead and tell you that they found at least one big mistake that they made in their process. Entities audited will be included in the evaluation but will not be audited again during this pilot study. That doesn't mean that they won't be audited again later. It's just that these folks are not going to go back on site anytime soon. And no fines were issued during this study. Penalties will be imposed, and this is different. Prior to 2009, there were a lot of audits. There were not inspections. They were just paperwork process. There were few fines imposed, and now almost every violation will incur a penalty. Now, there are some other things that have expanded this, in that penalty for one violation can actually be applied to more than just one covered entity, or more than one just one business associate, or both covered entities and business associates if both or all are involved. Generally speaking, the covered entity could possibly be held liable for penalties for the violations by its workforce, but also the business associate. Business associate now is also liable for penalties for violations done by its own workforce or subcontractors. So subcontractors at this point in time will not be audited or penalized. There are 4 categories of violations with increasing culpability and 4 tiers of penalties. There are a couple of provisions that prohibit or limit double jeopardy, and that is if a requirement or prohibition is found in one provision and repeated in yet another provision of the same subpart, the penalty can be imposed only on one of those provisions, not more than one. For penalties occurring for violations occurring before February the 18th, 2009, and yes, that was a long time ago, but there are situations where the Office for Civil Rights is pulling out violations or complaints received a long time ago and working them now, could not exceed $100 per violation or $25,000 for multiples of the same within the same calendar year. For penalties for violations occurring on or after February the 18th, 2009, they will be based on the 4 categories, the 4 tiers, and cap at $1.5 million. You can see there's a significant uptick here. The tiers start with the violation was not known and would not have been known even if the covered entity or business associate had conducted reasonable diligence, starting at 100, not capping as it previously did, going up to 50,000 with an annual cap for multiples at 1.5 million. If the violation was due to reasonable cause but not willful neglect, and we'll talk about that more in a little bit. It starts at 1,000, goes up to 50,000 with an annual cap of 1.5 million. If the violation was due to willful neglect but was corrected within 30 days, or it would have been known with reasonable diligence, it starts at 10,000, goes up to 50,000 with an annual cap of 1.5 million. I know that gets to be kind of redundant there. The highest level is willful neglect that is not corrected in 30 days. This is something pretty egregious, and the covered entity of or business associate just said, I'm not dealing with that. Should have been known. Starts at 50,000, goes up to 1.5 million. So we now have structured tiers based on culpability, starting with the could start at $100 on up to the very egregious in your face that starts at 50,000. How does the Office for Civil Rights ultimately determine the amount of the penalty? They look at the nature and extent of the violation, how many people were affected, and what was the duration of the violation. Then the nature and extent of the harm. Could it have been physical, financial, reputational harm? Could it have actually interfered with an individual's ability to obtain health care? And here's where we get into health care identity theft. Have there been prior violations? And then what is the financial condition of the covered entity or business associate? In other words, they're not going to try to bankrupt anyone. We have something called affirmative defenses, and this again has to do to some extent with preventing double jeopardy. So prior to February the 18th, 2011, if the violation was punishable under 42 U.S.C. 1320D-6, it could not also be penalized under HIPAA. On or after that same date, the violation has already been imposed under that statute. It cannot also be penalized under HIPAA. For violations occurring before February the 18th, 2009, there would be no penalties if the covered entity can prove that it didn't know of the violation and would not have been able to know of the violation even if they had conducted reasonable diligence, or they were involved in a circumstance that prohibited compliance, but it was not due to willful neglect and was corrected within 30 days, and then they could actually get an extension for this. And this is a very limited situation where perhaps there is another rule, another regulation that required them to be in violation of HIPAA. No penalties after 2009 if the business associate or covered entity can establish that the violation was not due to willful neglect and it was corrected within 30 days of discovery or within 30 days of the date that the business associate or covered entity should have known of the violation. The Secretary has the authority to grant an extension or even to waive penalties for uncorrected violations if it would be excessive for the violation itself. And when we're talking about the date that the violation should have been known, could go back to an employee who knew about the violation but didn't report it as they should have. Let's talk about that 42 U.S.C. 1320D-6. This regulation is wrongful disclosure of individually identifiable health information. Remember that the HIPAA regulations only cover entities involved in healthcare. But this can actually go against an individual, an employer, a healthcare provider, business associate, who knowingly and in violation of the regulations uses or causes to be used a unique health identifier, obtains individually identifiable health information relating to another individual, and discloses that information to an unauthorized individual. The maximum fine is 50,000 years and or 1 year imprisonment. If this is done under false pretenses, where I go out and steal someone else's Medicare card and make some changes on it and pretend to be them and go in and get health care, it can be $100,000 and or 5 years in prison. Now we go to the security rule, the purpose of which is to assure confidentiality, so it overlaps with privacy, availability, and integrity of electronic protected health information. Protected health information is any information about the health status, provision of health care, payment for an individual that can be linked to an individual using identifiers that HIPAA has listed for the HIPAA purposes. Here, listed on this slide, is all those identifiers, some of which we don't think of, and I know a lot of times practices in particular think that a medical record number or an account number is not considered an identifier because only they can link that with an individual. But it certainly is. A lot of things that we don't think about, such as device identifiers and serial numbers, vehicle identifiers, and so forth. Let's look at the security rule. The purpose of the security rule is to ensure confidentiality, so it overlaps with privacy rule, availability, and integrity of electronic health information. It protects against reasonably anticipated threats or hazards to security. Also to protect against reasonably anticipated inappropriate uses or disclosures that are not permitted or required, as well as compliance of the workforce. Remember, under HIPAA, the workforce includes management, providers, staff, volunteers, and even students. The security rule covers covered entities and business associates, requiring them to assess the implementation specifications in the rule to determine if this specification is reasonable and appropriate, or if an equivalent alternative might be better for them. Covered entities and business associates must document this assessment, including their decisions if they're going to use an alternative method. When we're talking about these safeguards, they're divided into 3 types: administrative, which is your risk analysis and management, sanctions, activity review, access review, supervision, training, and the contingency plan. Physical safeguards include facility access control, device and media control, disposal of protected health information, backup and storage, and contingency operations. Technical safeguards include passwords, protected health information, user authentication, integrity controls, encryption, and emergency access. There is an overlap between HIPAA and meaningful use. Now, meaningful use requires a security analysis, which is really the same as the security analysis done for HIPAA compliance. It includes that contingency plan, which becomes a little more important. A lot of covered entities pushed that button to say that they had done this so that they would get their money, and then after they did their attestation, they realized, oh my goodness, maybe we didn't. And in fact, CMS is recognizing that a lot said they did but didn't, and so they're now auditing practices to covered entities to make sure that they really did this security analysis and all the other things required under meaningful use, and are actually taking back some money that has already been paid out when covered entities were found to not have done what they said they did. Under the HIPAA requirements, we have something called a business associate agreement. We now have to revise those, whether we create new ones or amend the ones that are in place, to include some additional responsibilities. Now, the business associate agreement that Doctors Management has been using has been in compliance for a very long time. The good news here is that we now have a sample business associate agreement on the HIPAA website shown here for you. Business associates must also have a contract with their subcontractors that create, receive, maintain, or transmit electronic health information. And they must hold their subcontractors to essentially the same privacy and security regulations. Certainly the business associate agreement in our manual from 2010 was in compliance, and for 2013 we have decided to use the sample one provided by HIPAA, by the Office for Civil Rights, just adding places for customization for the actual signatures, dates, and so forth. Subcontractors must implement the same measures essentially as covered entities to protect confidentiality, availability, and integrity of protected health information. The business associates and their subcontractors must make the protected health information available to patients upon their request. The patients are generally going to go to the covered entity first. But if there is a situation where only the business associate or their subcontractor has that information, then the covered entity would refer the patient to them instead. Business associates are now subject to OCR inspections. Subcontractors at this point generally are not. Subcontractors are required to report breaches, and we'll talk more about breach notification, to business associates. Business associates are required to report the breaches to the covered entities, and then it's ultimately the covered entity's responsibility to take that forward and do everything that's required under the breach notification rule. There's certain documentation that's required with the security rule. Policies and procedures can be revised, but revisions must be in writing as well and must be implemented. All materials developed for HIPAA compliance must be retained for at least 6 years after it has been discontinued, and usually that you can't discontinue something until you've created it, but this is verbiage directly from the regulations. So anyway, when you decide you no longer need to use something, you've replaced it, you've revised it, you still have to keep the old stuff for at least 6 years, and it must be available to anyone who is responsible for implementation, as well as for representatives from the Office for Civil Rights that might do an audit or an investigation. Covered entities and business associates are required to periodically review and revise their policies and procedures based on changes to the regulations or changes in their actual facility or practices. Some things to be careful about when you are documenting. Document what you do. Make sure you do what you document. Failure to document will result in a fine. Failure to follow your documented policies or procedures will result in a fine. So this is why we always recommend that you keep your policies and procedures as general as possible so that you don't back yourself into a corner, because any enforcement agency will hold you to the strictest, whether it's the rules themselves or your own policies and procedures. Breach notification. Oh my goodness, this is huge. A breach is defined as acquisition, access, use, or disclosure of protected health information in a manner not permitted by the regulation which compromises security or privacy of the protected health information. Now, there are certain exclusions. These are basically internal disclosures that don't go outside the same entity, whether it's a business associate or a covered entity, or if the business associate or covered entity has reason to believe that the information would not have been retained by whomever received it. Any access, acquisition, use, or disclosure of protected health information in a manner not permitted by the regulation is now considered to be a breach unless proven otherwise. Previously, you were innocent until proven guilty, and now you're pretty much guilty until proven innocent, by demonstrating that there is a low probability that the protected health information has actually been compromised based on a risk assessment involving that breach that includes the nature and extent of the protected health information that was involved, the unauthorized individual or individuals to whom the disclosure was made, whether or not the protected health information was actually acquired or reviewed, and then the extent to which the risk has already been mitigated. An example here might be I work for a covered entity, and one of my responsibilities is to deliver laboratory results to the providers. And maybe I accidentally deliver the wrong results to someone, the wrong patient. Maybe I give Ann's results to Dr. B when they should have gone to Dr. C. It's just gone to the wrong individual, but it's all internal. Or maybe I send something in a sealed envelope. It actually leaves the facility, but I realize that I've put the wrong address on it, so I immediately call the wrong address, and I tell them, please hold that, I'm going to pick it up, I sent you the wrong information, and I go retrieve it. It hasn't even been opened, so it wasn't actually viewed, and it's already been mitigated. So that would be a situation where it might not be considered a breach. What is unsecured protected health information? This is protected health information that has not been rendered unusable, unreadable, or indecipherable to an unauthorized person through the use of a technology or methodology that's been approved by the Secretary of Health and Human Services. Breach notification applies only to unsecured protected health information in any format, and whether it's in motion, at rest, and sometimes perhaps even in use. At this point in time, the only methods that have been approved by the Secretary to render protected health information secured would be encryption and destruction. However, information that has previously been de-identified is not considered protected health information, so it is not considered a breach. On the flip side of that, limited data sets have been partially but not completely de-identified, so they are still protected health information that would be considered, could be unsecured under the breach notification rule if they have not been encrypted or destroyed. Notification under the breach notification, after a covered entity has discovered a breach, or they've had a breach reported by a business associate, they must first notify each individual whose unsecured protected health information has been or is believed to have been accessed, acquired, used, or disclosed as a result of the breach. It must be accomplished within no more than 60 calendar days after discovery or the date that it should have been discovered. The information that must be provided includes a discovery of the breach, including the date of breach if known and the date of discovery, a description of the type of unsecured information included, whether it's identifiers, diagnoses, payments, whatever, the steps that individuals who were affected should take to protect themselves from potential harm, what the covered entity is doing to investigate, mitigate, and prevent further breaches. And then also contact information for affected individuals to contact the covered entity for more information. Each individual who was affected or thought to be affected must be notified by first-class mail or by email, but only if the patient has previously agreed to receive a notice this way within 60 days of the discovery. If the individual has already passed away, the notification should go to the next of kin or the personal representative if possible. If there is not enough information to contact some individuals, and it's fewer than 10 individuals, then the covered entity must use some sort of alternative information to contact these individuals through telephone or maybe a letter that goes to a different address. If there is insufficient or outdated information concerning more than 10 individuals, then in addition to using these alternative methods, the covered entity must post this information about the breach on their website or in major print or broadcast media, and they must include a toll-free number for those individuals to call to get more information. If more than 500 individuals in one state or jurisdiction are affected by one breach, in addition to notifying the individuals affected, the covered entity must also notify the Secretary of Health and Human Services and must broadcast the information in some sort of media, whether it's print or broadcast media, within that state or jurisdiction. And this must include the same information and be done within the same time frame as the individual notification. If fewer than 500 individuals were affected, the covered entity must still notify all the individuals, but must enter that breach on a log, and then that log must be submitted to the Department of Health and Human Services within the first 60 days following the calendar year. The breach notification must be forwarded to the Department of Health and Human Services, the Secretary, using an electronic form on the website. If there are fewer than 500 affected, it can be the log. If more than 500, it must be immediately within 60 days of discovery. Then the Secretary posts these reported breaches on the HHS website. It's very interesting to look at this and see what kind of breaches have occurred. Some of them are very large, some of them are relatively small. Most of them have to do with lost or stolen laptops or storage media. Sometimes desktops have been stolen as well. The most entertaining one was a stack of paper charts that were left on the subway train. Following the discovery of a breach, a business associate must notify the covered entity within 60 days of the discovery, and they must provide the identification of the individuals affected plus any other information that they have available, and then the covered entity goes through the full process. The purpose of the privacy rule is to ensure confidentiality of protected health information. It applies to covered entities and business associates. Protected health information is information that can be linked to an individual by those identifiers that we showed you earlier, that any information that relates to condition, treatment, or payment transmitted or stored electronically or otherwise. So while the security rule only covers electronic information at this time, the privacy rule covers it almost in any format. The privacy rule forbids use of disclosures of protected health information that are not permitted by the regulations. Covered entities are permitted to use information, disclose information to the individuals for treatment, payment, and health operations, incident to use or disclosure otherwise permitted, pursuant to an agreement or authorization signed by the individual who is the subject of the information, to create de-identified information, or to a business associate under a business associate agreement. Covered entities may use protected health information unless otherwise restricted for the patient's treatment, for payment for the treatment given, and to carry out health operations or for the detection of fraud or abuse. Health operations include QA, QI, development protocols, customer service, evaluations, development of guidelines, certain public health activities, case management, care coordination, competency assessments and staff training, credentialing of individuals, business planning development. And one thing that doesn't seem to be understood by a lot of people is that it includes training new healthcare workers. Covered entities are required to release information to individuals who are the subject of the information. Upon request, there are always some restrictions that could apply, and then as required by the Secretary of Health and Human Services. Business associates are allowed to use or disclose information only as defined in the business associate agreement, including to a subcontractor who has to be under a contract that includes privacy and security. Business associates are also required to release information when required by the Secretary. Business associates and covered entities may not sell protected health information without a signed authorization from the patient. A sale is when the covered entity or business associate receives direct or indirect remuneration in exchange for the protected health information. Now, there are certain exclusions for public health or research purposes where the remuneration covers only the costs involved. And of course, to a business associate, or if the protected health information is sold as a part of the practice, obviously it becomes part of the practice, to the individual who is the subject of the information or as permitted by law. GINA, Genetic Information Non-Discrimination Act of 2008. Genetic information includes the individual's genetic test results for the individual's family, manifestations of the disease or disorder in family members, request or receipt for genetic services, participation in clinical research, which includes genetic services by the individual or the individual's family members. The Genetic Information Non-Disclosure Act of 2008 clarifies that genetic information is protected under the privacy rule, prohibits health plans from using or disclosing information for underwriting purposes with the exception of long-term care plans. It also prohibits employers from using pure genetic information without manifestation when it comes to hiring. We have minimum necessary. This has been around since the inception of the privacy and security rules. This says the minimum necessary to accomplish the purpose. It applies to disclosing or using protected health information or requesting protected health information to or from a business associate. Applies both to business associates and covered entities. Previously, covered entities relied upon the request from the individual or entity to determine what was minimum necessary. And now covered entities are responsible for directly determining what is the minimum necessary for this use. Covered entities must, as much as possible, limit the use, disclosure, request, or protected health information to a limited data set by removing identifiers as much as possible. If that is not possible, the covered entity must limit as much as possible, again, the protected health information to what is absolutely necessary to accomplish the intended use. There have been some changes concerning protected health information of a deceased individual. Originally, it was protected indefinitely, and now that protection extends only for 50 years after death. It now allows individuals who were involved in the decedent's care or payment to access protected health information without written permission from the personal representative unless this access had already been restricted prior to the patient's death. The HIPAA regulations have really defined what a family member is, and they have gone into great detail for this. Next slide. A family member with respect to an individual includes a dependent of the individual, any other person who is a first degree, second degree, third degree, or fourth degree relative of the individual or of a dependent of the individual. It also includes relatives by affinity, such as marriage or adoption, and these are individuals are treated the same as relatives by consanguinity, that is, relatives who share a common biological ancestor. So they've really done their due diligence on those definitions. That helps, though. It does help. Covered entities are given the authority based on professional judgment to not treat someone as an individual's personal representative if the covered entity believes that the patient may have been subjected to domestic abuse, violence, or neglect by that person, if they perceive that treating that person as the personal representative could endanger the individual, or it is otherwise not in the patient's best interest to do so. That's based on professional judgment. It can't be just because we don't like that person. That person's been rude to us. Personal representatives are those who have the authority to act on the behalf of an individual in making health care decisions. The covered entity must treat personal representatives the same as the patient. We have unemancipated minors, and this is where state laws come into effect. This, when we have an unemancipated minor, usually the parent, guardian, or person acting in loco parentis is considered the personal representative of an unemancipated minor. Now, there are always exceptions, and never say always or never. If the minor is allowed by law to consent to a certain type of treatment, or if that personal representative has agreed to confidentiality between the minor and the provider, then the personal representative is the patient himself or herself, not someone else. Under the omnibus rule, we have a new restriction ability, shall we say. Patients have always had the right to make certain restrictions, but we weren't always required to comply with these. And previously, all patient services had to be reported to the insurance companies, to the health plan. Now, under the new omnibus rule, patients have the right to request that certain information not be reported to their insurance company for a service or an item for which the patient pays for entirely out of pocket. Now, yes, another individual that's involved in the person's payment can make the payment, but they cannot involve another insurance company. The covered entity must comply unless there is another law that is in conflict. For example, Medicare is part of the Social Security Act, and it requires covered entities to report every encounter. So this restriction would not apply to Medicare beneficiaries. Patients have the right to request in writing a restriction for disclosures on uses of protected health information. Covered entity is not always required to comply with that request. Covered entities are now required to agree to that request, provided the patient pays in full, there is no involvement of any insurance company, and there is no law to the contrary. This restriction applies only to health plans and only for services or items for which the patient paid entirely. Other uses or disclosures are not affected by this restriction. From a practical standpoint, this can be quite cumbersome. This service or item must be documented, but it must be isolated in such a way that it does not go to the insurance company. So we may create a chart within a chart, which is pretty simple to do if you have paper charts, which almost no one has anymore. I have been told that most electronic health records actually have an area, a part of the record, that is not otherwise designated, so it can be used for that purpose. But somehow it must be flagged so that it is not submitted to the health plan. If the patient does not pay in full, the practice may then report the service to the insurance company. Credit cards are going to be accepted or denied immediately, but a check might bounce. Good business practice would mean contacting the patient and giving them an opportunity to pay through some other method, but you do have the right then to go ahead and get paid for what you've provided for the patient. This does not give them an out financially. Disclosures by whistleblowers. A covered entity is not considered to be in violation of the HIPAA regulations if a member of its workforce, a staff member, a student, a volunteer, or of a business associate discloses protected health information if the workforce member or business associate believes that the covered entity is engaged in conduct that is unlawful, unprofessional, outside clinical standards, or endangers staff members or patients, and the disclosure is to a health oversight agency or public health agency authorized to investigate such complaints, or if the member of the workforce or business associate has retained legal counsel to determine the options concerning the situation, or if the member is the victim of crime and the information results to that crime. So this is protection for whistleblowers under very restricted situations where there seems to be something going on that absolutely should not go on. Business associate contracts. We've mentioned earlier that these need to be renewed. A covered entity is not considered to be in compliance if the covered entity is aware of an activity or practice that the business associate is involved in that is a breach or violation, unless the covered entity takes measures to stop the breach or end the violation, or if that was not successful, they terminate the agreement. Now, previously it was just the covered entity had to cure the breach or end the violation or terminate the agreement. Now, a business associate is in compliance if they are aware of something going on at the covered entity that is a breach or violation, unless the business associate does the same thing, takes measures to stop the breach or end the violation, or if that is not successful, they terminate their agreement. So this is reciprocal now. Business associate contracts must establish permitted or required uses of protected health information, may not allow uses or disclosures beyond what is allowed by law, may not permit business associates to use protected health information. It may permit business associate to use the protected health information for management and administration of their own business. And they may use it to provide data aggregation services to the relative to the healthcare operations of the covered entity. Business associate contracts or business associate agreements must require the business associate to use or disclose protected health information only as permitted or required by the contract or by law. Requires business associates to use safeguards to protect protected health information, to prevent disclosures other than as provided for in the contract or the regulations. Business associates must report any breach that it discovers to the covered entity, must establish, this is new, a similar contract with its own subcontractors, must make available to patients upon their request any patient information, including amendments that are requested as a part of an accounting of disclosures, must make its policies and procedures available to the Secretary of Health and Human Services. Business associates are now subject to audits and investigations. Business associate agreements or business associate contracts must require the business associate to return or destroy any protected health information it possesses at termination of the contract. It authorizes the termination of the contract at the request of either the covered entity or the business associate who believes that the other is in violation. There are certain uses and disclosures of protected health information that require an authorization. Back in the day when HIPAA first came out, consent was required to be signed by the patient before the covered entity could use protected health information for treatment, payment, or health operations. That was realized to hinder health care, so that was eliminated very early on. So it is no longer required, but that doesn't mean it's forbidden with one exception. A consent cannot be used where an authorization is required. An authorization is required for use or disclosure of psychotherapy notes except for the treatment, payment, or health operation, or by use from the originator or for legal actions. And this is a little bit of a disconnect here. Generally speaking, patients are not allowed access to their own psychotherapy notes, but they are required to give authorization for use or disclosure outside really treatment, payment, health operation by the originator or for legal actions. An authorization is required for marketing, with the exception of face-to-face or minimal value, or for the sale of protected health information. These are strengthened requirements of the use of an authorization for or for covered entities or business associates. There is a special disclosure that is kind of exciting, especially for pediatrics, family care, primary care. Covered entities may now release proof of immunizations to schools in states that require immunization for school enrollment without a written authorization from the individual or personal representative. The covered entity, however, must have some type of agreement, and that type of agreement must be documented. That's usually a verbal agreement over the phone. They must have some type of agreement, and that agreement must be documented, but it doesn't have to be a signed authorization, and that's very helpful. Authorizations must meet certain requirements, very specific requirements, must not have been expired or revoked, must be totally filled out, must not include false information, and must be in writing. Generally speaking, authorizations may not be combined with other authorizations except when it has to do with research. And authorizations may not condition treatment except with respect to research. Elements required of an authorization: a description of the protected health information to be used or disclosed, identification of the entities authorized to release and to receive the information, the purpose for the use or disclosure, an expiration date or event. This must be specific. It could be until I retire, until I'm released from your care, for 5 years, 10 years, whatever. It must be signed by the individual. It must have a date. And it could be the personal representative if there is such. The authorization must include, on that same piece of paper, the individual's right to revoke that authorization in writing going further. Obviously, or going forward, we can't take back information that's already been used or disclosed. It must include how the patient can go about requesting a revocation, must be in plain language, and a copy of the signed authorization must be given to the patient. There are certain situations in which the patient must be given an opportunity to agree to or to object to facility directors. In an emergency, however, this may be superseded. In other words, if the patient is unable to object and there's someone else who determines it's in the patient's best interest to do so, you can go ahead and dispense with giving the person the opportunity. This is very limited situations. Facility directories, that usually means hospitals, long-term care, and so forth, usually does not apply in private practices. There are certain uses of disclosures in which an authorization or opportunity to object is not required. Uses of disclosures required by law for public health, situations involving abuse, neglect, or any sort of abuse, healthcare oversight, workers' comp, judicial and administrative proceedings, law enforcement, about decedents to coroners, medical examiners, and funeral directors as part of their job for good cadaveric organ, eye, or tissue donation for research as long as it's under an institutional review board. Fundraising. Most covered entities don't contact their own patients for fundraising purposes, but if they're going to do so, first of all, it has to be included in the Notice of Privacy Practices. It is limited to the information listed here. The covered entity must provide the individual with an opportunity to opt out of these communications without any repercussion with each communication. Once a patient has opted out, that opt-out stays in effect until the patient says otherwise. Notice of Privacy Practices must begin with a statement that's right out of the Federal Register, must include description and at least one example of ways that information can be used for a treatment payment health operation, a description of other uses that don't require an authorization, a description of uses that do require authorization, including the right to revoke that authorization, uses and disclosures permitted or required by law, and if the covered entity plans to contact the patient for fundraising, this must be stated in the Notice of Privacy Practices along with the opportunity to opt out. The Notice of Privacy Practices must explain the patient's right concerning their protected health information, their right to request restrictions, to request confidential communications, to inspect and copy, to request an amendment, to receive an accounting of disclosures, and now we have to allow them to receive that accounting of disclosures electronically if they so request, and it's possible to do so. We also have to include the right to receive their Notice of Privacy Practices electronically if they so wish. We must include in the Notice of Privacy Practices how individuals may file complaints with the covered entity and with the Secretary, including the name or title and phone number of the contact person within the practice and how to contact the Secretary. The Notice of Privacy Practices must include the covered entity's requirements to maintain privacy, to provide notice of legal duties and privacy practices, to comply with its own Notice of Privacy Practices, to revise the Notice of Privacy Practices when indicated, to provide individuals with the revisions. And here are two new things. The Notice of Privacy Practices must include the covered entity's requirement to notify individuals involved in a breach of unsecured protected health information, and that the covered entity must grant requests to restrict information to health plans about the service or items paid for by the patient, and of course they're going to make that request in writing. And it also must include the effective date of the Notice of Privacy Practices. So today we have to revise our Notice of Privacy Practices. The effective date would be when it's first printed, not 2003. And please don't backdate it to September 23rd, 2013 if your practice doesn't open until 2014. That's going to look real suspicious. The Notice of Privacy Practices must be made available to anyone upon request. For covered entities that have direct treatment relations with the patient, must provide the notice by the first date of the delivery of service. In an emergency, as soon as possible after the emergency, must make a good faith effort to obtain a written acknowledgement of the receipt of Notice of Privacy Practices. Very often patients don't understand what we're asking them to sign and they decline. Must have the notice available at the service delivery site, must display the notice in a prominent location, must make revised notices available upon request after the revision. Covered entities that maintain a website that includes information about their services or benefits must post their Notice of Privacy Practices on the website and must make it available electronically through the website. It must be identical to the notice that is posted and that is offered. The notice may be submitted or offered or provided electronically if the individual agrees to see it that way, to receive it that way. And if the electronic transmission fails, then a paper copy must be provided. If the first service delivery is electronically, the provider must include an electronic notice with the first request. The individual who received the electronic notice still has the right to receive a paper copy upon request. A covered entity that participates in an organized healthcare arrangement may actually have a joint notice or may have a separate notice, either way. Anytime the notice and the written acknowledgement is changed, the originals must be kept for at least 6 years. So under HIPAA, absolutely everything must be retained for a minimum of 6 years. After it's revised, changed, discontinued, it still must be kept for 6 more years. Patients have the right to request restrictions on use and disclosure of protected health information for treatment, payment, health operation, but the covered entity is not required to agree to those requests, with that one exception that we've already discussed. If the covered entity agrees, it must comply with that agreement, with the exception of an emergency situation, and then they must make sure that that information is not further used or disclosed after the emergency is resolved. The covered entity is required, once again, to agree to a restriction that involves a service or item for which the individual has paid in full and for which there is no law that is contrary to that. The covered entity is not required to communicate these restrictions downstream to other covered entities. The covered entity may terminate this restriction provided the patient is informed in advance in writing and the patient agrees to that termination, and it affects protected health information only after the agreement is in effect. Patients have the right to request confidential communications. They may want the covered entity to only call their cell phone, to not call their home phone, to send information in a sealed envelope, not using a postcard. The covered entity may require this request to be in writing. They are required to accommodate a reasonable request if it is an effective alternative, but may condition the accommodation on payment if it costs them extra money, and they would certainly require the requesting individual to give an actual alternative address or method in case the requested method does not work. The covered entity may not require the requester to explain why they want this alternative method. Individuals have the right, in most cases, to get a copy of their protected health information, with the exception of psychotherapy notes, as mentioned earlier, information to be used for civil, criminal, or administrative action, or information to date as covered by the Clinical Laboratory Improvement Amendments. In the CLIA regulations require laboratories to release information to the authorized individuals who ordered the information, and we have that pending rule to require clinical laboratories to give the information directly to the patient, but that's still pending. Covered entities may deny access without an opportunity to review if the covered entity is a correctional institute or acting under a correctional institute where access could jeopardize the safety of the individuals, other inmates, or staff members. If the individual is involved in research, or if the protected health information was received under some sort of confidentiality contract. The covered entity that denies access must explain in writing why they have denied that, and must provide redacted information that would exclude the information that should not be allowed to get to the individual. There are some changes in the way that covered entities are required to provide copies if requested. covered entities must now provide the information in electronic format if possible. If not, then a readable paper copy. If the information is electronically, it must be provided to the requester in a form and format acceptable to the requester. The covered entity has the right to say, we would like to provide you with a summary instead of the entire record, and if the requester agrees, that's fine. Otherwise, it would have to be the exact copies. The covered entity has the right to charge state-determined fees for paper copies and reasonable cost-based fees for the summary. When patients request their information in an electronic format, covered entities must provide it in a format that is acceptable to the requester. Covered entities may not require requesters to purchase media from the covered entity, but should not accept media brought in by the requester. That's a good way to spread viruses and so forth. It's not wise to accept media brought in by someone else. The information may be transmitted through email if the requester agrees to this, with the understanding, if applicable, that it may not be secure. So if your email system is not encrypted, that should be included on the request, and the requesting individual should be made to understand that someone else may be able to access this information inappropriately. Patients have the right to request an amendment of their protected health information. This should be done in writing and with an explanation. The covered entity has the right to deny the amendment. First of all, if the protected health information was created elsewhere, if it is not part of the designated record set, if it is not available for inspection, or if the record is already, and this is the primary reason, if the record is already accurate and complete as it stands. If the covered entity does require to make the amendment, it must do so in 30 days, but may have one 30-day extension as long as it informs the individual who requested. If the covered entity denies the amendment, the patient has the right to appeal or to file a complaint. All of these requests become part of the designated record set, whether they're denied or accepted. Accounting of disclosures, and this is something that patients have always had the right to as long as HIPAA has been in effect. Very seldom does anyone request it. The patients today have a right to an accounting of disclosures as far back as 6 years, but omitting treatment, payment, health operations, or incident to a permitted use, or a disclosure to the patient, or pursuant to an authorization signed by the patient, or for the Directory for National Security, Correctional Institutes, Law Enforcement, part of a limited data set, or before the covered entity's compliance dates. The accounting of disclosures must include the date of the disclosure, the name of the entity or person who received the disclosure, including the address if known, a description of the protected health information disclosed, and the purpose of this disclosure. It must be provided within 30 days of the request, within 30 days, one 30-day extension if there are extenuating circumstances. The first accounting of disclosures must be provided free. If someone requests a second one within 12 months, they can charge for the second one in 12 months. Business associates are also required to disclose information if they are requested for an accounting of disclosures. Disclosures to business associates may very well be included in the accounting of disclosures prepared by the covered entity. Covered entities may not sell protected health information unless it has a specific authorization from the patient. We listed some exceptions earlier, and those still stand. They're kind of obvious, and we're supposed to get a little more details about that later. HIPAA requirements include certain administrative responsibilities for covered entities. There must be a privacy officer, must have written policies and procedures for protecting information, must train their workforce, and remember the workforce includes a lot of people. It includes students, volunteers, management, providers, must train all new hires, must periodically remind everyone, must have and follow a sanction policy, must not retaliate against anyone, whether it's a patient or staff member who files a complaint, must be in compliance with the new regulations by September 23, 2013. There are certain things that were included in HITAC that were not included in the omnibus rule. This is what we mentioned earlier about laboratories giving test results directly to the patients. That's on hold. Requiring covered entities and business associates to include in their accountings of disclosure uses and disclosures for treatment, payment, and health operations going back 3 years based on implementation date of an EMR. So that luckily did not come forward. And also requiring covered entities to provide a list of names of individuals who access protected health information. So this did not come forward in HITAC. HIPAA does require training for the entire workforce, initially upon hire. Training must be applicable to what the individual is required to do. It must be done again if there are any changes in the regulations themselves or your unwritten policies or procedures. Must have periodic updates. They don't really define periodic. We interpret that to be a year. And the training must be documented. This concludes our session on Omnibus Rule. We thank you for your attention and hope you found this information helpful.